The European Union's AI Act is, without a doubt, a landmark piece of legislation. But its real power isn't just in the rules it sets, but in how it's enforced. Today, we're going to dissect that enforcement engine, specifically focusing on Article 74. It's important to note that this analysis was conducted under the scientific oversight of Professor Vihar Kiskinov, Doctor of Legal Science.
So the EU has created one of the most comprehensive rulebooks for artificial intelligence anywhere in the world. But that brings up the big question. Once the rules are on the books, who's the referee on the field? I mean, writing the rules is one thing, but making sure everyone actually plays by them, that's the real game.
To really get our heads around this, we're going to break it down into 5 parts. First, we'll look at why having a referee is so important to begin with. Then, we'll dive right into the heart of the matter, Article 74, the enforcement engine itself. After that, we'll peek inside the AI Inspector's Toolkit, see how it all works in a real-world case study, and finally, we'll map out the whole network of authorities that make up this new digital watchdog.
Okay, let's start with a basic truth. Any law, especially one that's trying to regulate something as powerful and fast-moving as AI, is really only as good as its enforcement.
Just think about that for a second. Without any real oversight, without any consequences, all those detailed requirements for safety and fairness in the AI Act, well, they become little more than well-meaning suggestions. What we absolutely need is a framework that's both strong and flexible enough to make sure the AI systems that are part of our lives are genuinely safe and playing by the rules.
And that brings us right to the core of our discussion, Article 74. This is the EU's answer to the enforcement problem. You can think of it as the engine that makes the whole regulation actually run.
So what is Article 74 really? It's the absolute linchpin holding the entire enforcement structure together. And what's really clever here is that the EU didn't try to reinvent the wheel. Instead, they took a system that already works and adapted it for this new world of AI. And here's the key. Article 74 essentially plugs AI systems into the EU's existing, well-oiled machine for market surveillance. This is the same framework that checks if toys, cars, or medical devices are safe for the public. By doing this, the EU is making a clear statement. AI is a product, and just like any other product, it has to be safe, both before and after it hits the market. Now, this article didn't just pop up fully formed. It went through a pretty significant evolution. The first proposal back in 2021 laid the foundation. By 2022, it was refined to include a way for the public to file complaints. But it was the final 2024 version where it really gained its teeth, adding critical new powers like remote inspections and even access to source code.
All right, so let's open up this toolkit. What are the specific powers that Article 74 gives these new AI inspectors?
First up, and this is absolutely critical for digital products, is the power of remote inspection. This means authorities don't have to show up at a company's doorstep. They can inspect an AI system digitally, which makes total sense for software that could be running on a server anywhere on the planet.
Second, they get access to data. And we're not talking about just any data. They can demand the technical documents and, crucially, the data sets that were used to train, validate, and test a high-risk AI. This lets them pop the hood and see exactly what the AI has been learning. And third, we have the most powerful tool of all, conditional access to the source code. Now, this is a big deal, and it's treated as a last resort, only used when it's absolutely necessary to see if a system is compliant. It's a perfect example of how the Act tries to balance powerful government oversight with protecting a company's intellectual property. These tools sound pretty potent in theory, right? But what does it look like in practice? Let's walk through a case study that shows exactly how this would all play out.
Okay, here's our scenario. A company is using a high-risk AI to sort through job applications. The problem? There are whispers, maybe some complaints, that the tool seems to be biased against female candidates, a clear potential violation of fundamental rights.
So how does the investigation unfold? It kicks off when a complaint is filed, or maybe a national authority spots a red flag on its own. Using their Article 74 powers, they demand to see the training data. The analysis confirms it. The system is biased. But here's the key part. The final step isn't just about handing out a fine. The authority can order the company to take corrective action, like retraining the model, to actually fix the problem. The goal here is compliance, not just punishment.
Now, you might be imagining some big central AI police force was created for all this, but that's not quite how it works. What Article 74 actually builds is something much smarter and more sophisticated, a coordinated network of existing experts. The whole framework is designed to tap into the expertise that's already out there. The new Central AI Office plays coordinator, but the actual on-the-ground surveillance might be done by financial regulators looking at banking AI or data protection authorities checking for privacy issues. It's a multi-layered system that puts the right experts on the right case.
So who are the players on this team? You've got your national authorities on the front lines, specialized regulators for different sectors, and of course, the data protection authorities. At the EU level, the new AI office coordinates everything, while the AI board helps them all cooperate. This structure really follows a core EU principle. Let the member states designate the best local body for the job.
To really get the EU strategy, it helps to compare it to what it's not. In places like California, enforcement often depends on individuals suing companies after something's already gone wrong. It's driven by private lawsuits. The EU model under Article 74 is fundamentally different. It's a public-led approach, where the state proactively watches the market to prevent harm from happening in the first place. It's a philosophy that sees safety and fundamental rights as a public responsibility.
So, when you put it all together, what do you get? As this quote from the source material sums it up perfectly, the journey of Article 74 shows a clear progression. It has evolved into a system that is robust in its powers, flexible in how it's applied, and deeply collaborative in its structure.
The architecture is impressive. The tools are there. A new kind of digital watchdog has been created. But the real question, the one we're left to think about, is this. As this technology continues to advance at an incredible pace, will this watchdog truly have the teeth and, just as important, the resources to tame the future of AI? That is the challenge that lies ahead.